All right, guys. So, all right, let me give you all the backdrop on it. Some of you all have heard it before. Me personally, I started out with the just simple contract law, understanding and reading over lots of old law books. And this information has been my life's passion thus far. Like I haven't found anything else that has given me this much passion to study and grow and create and try to help people. Now, along my way in my journey, I came up on some of the most simple concepts that the average person does not know, and it's just so we complete so many processes every day, and so many things are working in the background that we don't realize that we complete contracts and acceptance and agreements and covenants with all sorts of sources on a daily basis, and you don't understand that sometimes when you run into certain type of situations where you are fined or penalized or go to jail for failure to appear or someone reporting negative information on your credit report, any of these things, okay, it all comes back down to everybody who's your owner, okay? You have limited ability to use certain things. So, for example, the use of your name is taxed. It's taxed. If you don't believe me that it's not taxed, guys, when you look at your paycheck and you see that money already missing for the time that you work, the use of your name is taxed. You are taxed. You are treated as a property of something or someone. Okay, you are put under a system of oppression. Most people do not see. If you would think in your mind, if I gave you a $250 traffic ticket next week, how would that mess up your budget? Okay, or next month you have an extra $250 you got to pay out for having two headphones in your head. All right, so let's get down. Let's get down into the meat. Okay, this is the first. What we're about to be going over tonight. Please take notes. This is the very first definition that I've researched or studied that really breaks down from top to bottom, okay, what is going on. I mean, it opens up a very broad spectrum, but it does give you a very good detailed breakdown of it, just by definition. Okay, I love when you get a definition of a word and you really, if you want to learn something, just learn what every word means. Okay, all right. We're going to start with the statutes of uses. So write this word down. Statute of uses. STATUTE of uses. This is pertaining to why we want to be owners of the title of our birth certificates. Okay? This is why. This is the history of it. This is how it came about. Why is it even necessary to have to even go through the process of authenticating your birth certificate, turning your copy of the certificate into an original, and claiming ownership of it? Okay? Can I get someone to volunteer that does have screen share tonight to read for me? I want to say anybody that can see, if you don't mind.
All right. Statute of Uses. The Statute of Uses 27 Hen 8 C 10 was an act of the Parliament of England that restricted the application of uses in English property law. The statute was originally conceived by Henry the Eighth of England of England as a way to rectify his financial problems by simplifying the law of uses, which moved land outside.
Statute of
Hold on one
uses.
second. Hold on. Go ahead. Go ahead.
That thing is blocking me. Yeah.
There you go.
All right, the statute was originally conceived by Henry VIII of England as a way to rectify his financial problems by simplifying the law of uses, which moved land outside the royal tax revenue, traditionally gathered through cession. His initial efforts, which would remove uses almost completely, were stymied at the 1529 Parliament by members of the House of Commons, many of whom were.
All right. Notice that it was to simplify the law of uses, which moved land outside of royal tax revenue. See that? This is where it started, the law of uses. There were certain uses that were taxed, and to get outside the royal tax of a king. Okay? Now, you know we're in America, and you're probably wondering how does this in England have anything to do with us, but guess what? It has a lot to do with us because there's no kings here. No kings in America, but you still got income tax. So who? Go ahead. So it was by the members of the House of Commons, many of whom were, go ahead.
Many of whom were landowners who would lose money and lawyers who benefited in fees from the confusing law on uses. Academics.
Oh, you hear that? Look who stopped it. Look who didn't want this to go through. Landowners, the big boys, and the lawyers who benefited in fees for the confusing law on uses. A lot of people benefit from the confusion of your income tax. You got CPAs, tax preparation. What else? You got tax collectors, IRS agents. A lot of people who benefit from your job. Your job, you to hold on to those taxes. Okay, so but especially the lawyers. Go ahead.
Academics disagree on how the commons were brought around, but an eventual set of bills introduced in 1535 was passed by both the Lords and Commons in 1536. The eventual bills invalidated all uses that did not impose an active duty on trustees, with the beneficiaries of the use being held as the legal owners of the land, meaning that they had to pay tax. The statute partially led to the pilgrimage of grace and, more importantly, the development of trust. But academics disagree as to its effectiveness, while most agreed that it was important, with Eric Ives writing that the effect which its provisions had upon the development of the English land law was revolutionary. Some say that by allowing uses and devices in certain areas, it not only failed to be removed the fraudulent element from the land, but actively encouraged it.
Okay. Go ahead. All right, so let's come on, drop down to background. Let's get some background on what are we talking about? What do you mean statutes of uses? You should be thinking in your mind, what are uses? It's something. Okay, so let's get some background on it. Let's get right there, the common law.
All right, background. The common law of England did not provide for a way to dispose of land held by feudal tenure through wills. Only earthen land.
Through wills. All right, hold on. So, I know no one in here knows what feudal tenures are. So, all right, let's click on that. So now we're on land tenure. Go ahead.
Land tenure is a name given particularly on common law systems to the legal regime in which land is owned by an individual who is said to hold the land. The French verb tenure means to hold. Tenant is the present participle of tenure. The sovereign monarch, known as the crown, held land in its own right. All private owners are either tenants or subtenants. The term tenure is used to signify the relationship between tenant and lord, not the relationship between tenant and land.
Okay, so hold on 1 second. Now y'all notice that land tenure sounds a lot like something a lot of people may have right now. A landlord. You hear that? Tenants and subtenants. So this verbiage is not new to you, okay? It's just now let's open your mind out so you can see what this system is, okay? Go ahead. Over history.
Over history, many different forms of land ownership, i.e. ways of owning land, have been established. A landholder/landowner is a holder of the estate in land with considerable rights of ownership, or simply put, an owner of land.
Okay, so how many people knew that there was more than one way of owning land? Okay, most the average person, as people who they have been tenants for a while now. Okay, we don't even know about the concept of how you own something, the ways of owning something. Okay, all right, let's drop down. We're gonna keep going. The feudal tenure.
Feudal tenure. Historically, in a system of feudalism, the lords who received land directly from the crown were called tenants-in-chief. They doled out portions of their land to lesser tenants in exchange for services, who in turn divided it among lesser tenants. This process, that of granting subordinate tenancies, is known as sub-infeudation. In this way, all individuals except a monarch were said to hold the land of someone else. Historically,
okay. So now think about the system that you just heard. It's the crown, then the lords, and then the landholders, and then the tenant. Now we've been at the tenant. We're 90%, 99% of the people, if not more, the people are in the tenant position. Okay? When we say take your name back and get your birth certificate and claim ownership, we're trying to take you out of the tenant position and put into the crown position, guys. In America, the people hold the crown. Go ahead.
Historically, it was usual for there to be reciprocal duties between lord and tenant. There were different kinds of tenure to fit various kinds of duties that a tenant might owe to a lord. For instance,
hold on.
A military.
Now, I want to give y'all another form of tenure. Your landlord is supposed to make sure the property is upkept with the grass service, and in turn, you pay rent for X amount of dollars per month. That's a form of what the lord's supposed to do, and as a tenant, what you're supposed to do. You must upkeep, make sure it's maintained and not damaged, etc. Okay? But here's another form of tenure. For instance, go ahead.
For instance, a military tenure might be night service.
Hold on. The draft. See that? I'm trying to show you there's other tenures in this system. You remember there was a time when you had to give night service to the U.S. Army? Military drafts in the 60s. Go ahead.
Requiring the tenant to supply the lord with a number of armed horsemen. The concept of tenure has since evolved into other forms, such as leases and estates.
Okay, so do you want to have a lease or an estate? Okay, when you're a lease, you're a tenant. You're at the bottom of the or the feudal system. Okay? So if you at the bottom of the feudal system, you wanna be in an estate. Okay? We're gonna get to that. Part of your estate that you need to put in your estate will be your birth certificate. Okay? Modes of ownership and tenure. Go ahead.
Modes of ownership and tenure. There is a great variety of modes of land ownership and tenure. Traditional land tenure. For example, most of the indigenous nations or tribes of North America had no formal notion of land ownership. When Europeans first came to North America, they sometimes disregarded traditional land tenure and simply seized land, or they accommodated traditional land tenure by recognizing it as aboriginal title. This theory formed the basis for treaties with indigenous peoples.
That definitely, y'all want to research that on a later topic, okay? I will get back to that, but we're going to keep it business. Go ahead.
Ownership of land by swearing to make productive use of it. In several developing countries as Egypt, Senegal, this method is still presently in use. In Senegal, it is mentioned as misuse en valeur des zones de territoire. And in Egypt, it is called wada al-yad. Allodial title, a system in
allodial title. Yes. Now, this is a very important term. Allodial title. Make sure y'all write that down. Y'all need to know what allodial title is. Let's get the cliff note of it.
Allodial title, a system in which real property is owned absolutely free and clear of any superior landlord or sovereign. True allodial title.
Okay, so there you go. You got to slow down just a little bit because you know I'm going to jump in on something like that. Now, y'all, did you hear that? It is a system in which real property is owned absolutely free and clear of any superior landlord or sovereign. Guys, I hope if you're on this call, and some people ask, if you ask me and I can't give you any clear answer on what are some of the not having the benefit, what are some of the side effects of claiming the ownership of your birth certificate, I don't want to be under a system of where somebody else has my allodial. Okay? The allodial title. And guess what? You can switch that name out, allodial title, with birth certificate. Okay? Your allodial title. Let's get it. All right? Go ahead.
True allodial title is rare.
Oh.
With most property ownership in the common law world, Australia, Canada, Ireland, New Zealand, United Kingdom, United States, being in fee simple. In fee simple.
I'm going to read this again. Let me read this again. True allodial title is rare. Most property ownership is in the common law world is being in fee simple. Fee simple. Let's get fee simple. Now, this is what most people in the world are operating under this. Go ahead.
Fee simple. In English law, a fee simple or fee simple absolute is an estate in land, a form of freehold ownership. It is a way that real estate may be owned in common law countries and is the highest possible ownership interest that can be had in real property.
Hold on now, guys. Hold on, guys. Wikipedia just lied in bald face. Right there in your face. Listen very closely. Now, I'm going to back up. We just read allodial title. Allodial title is a system in which real property is owned absolutely free and clear of any superior landlord or sovereign. True allodial title is rare. With most property ownership in common law world is being in fee simple. So how is allodial title superior? And then you click on fee simple, and fee simple says that it is a freehold ownership in which is the highest possible ownership and interest that can be held in real property. Listen now and keep reading. Allodial title.
Allodial title is reserved to governments under a civil law structure. The rights of the fee.
So they say that it's reserved only for government law structures. How did it come to that? When did it get to where it's government law structures that are the only thing that holds allodial title? Okay? Understand that once you set up an estate, your estate is a government civil law structure. You can hold this status. You can be this right here. Okay? Right now you're not, but you can be this. What they're defining under only held for government law structures. Okay? I'm not going to dig too deep on estates. Go ahead. The rights of fee.
The rights of the fee simple owner are limited by government powers of taxation, compulsory purchase, police power, and escheat. And it could also be limited further by certain encumbrances or conditions in the deed, such as, for example, a condition that requires the land to be used as a public park with a reversion interest in the grantor if the condition fails. This is a fee simple conditional.
Okay, so the rights of the fee simple owner are limited by the government powers of taxation. Don't they sound like the powers of the king to tax? So your government has become your king? How? How has the government become the king? All right. History, the word fee. Go ahead.
The word fee is derived from fief, meaning feudal landholding. Feudal land tenures existed in several varieties, most of which involved the tenant having to supply some service to his overlord, such as knight service. If the tenant's overlord was the king, grand suzerainty, this might require providing many different services, such as providing horses in the time of war or acting as a king's ceremonial butler. These fiefs gave rise to a complex relationship between landlord and tenant, involving duties on both sides. For example, in return for receiving his tenant's fealty or homage, the overlord had a duty to protect his tenant. When feudal land tenure was abolished, all fiefs became simple, without conditions attached to tenancy.
To the tenancy. So, listen to the same, is that your government is trying to replace the king, okay? That you might have some services of the overlord. Now that it's simple, you might just have some more taxations, like speeding tickets, stop sign tickets, no license plate ticket. You got to have a driver's license. You got to have insurance, or we're going to give you another ticket. Jaywalking, take you to jail. Spitting on the ground, that's another ticket. Okay, these are some of the feudal penalties in common law. Go ahead. In English common law.
In English common law, the crown has radical title, or the allodium of all land in England, meaning that is the ultimate owner of all land. However, the crown can grant ownership in an abstract entity called an estate in land, which is what is owned rather than the land it represents. The fee simple estate. The fee simple estate is also called estate in fee simple or fee simple title.
Okay, so state in fee simple or fee simple title, your first, middle, and last name in uppercase is a fee simple estate. The exact same thing.
Sometimes
Okay?
simply free.
Go ahead.
Sometimes simply freehold in England and Wales. From the start of the Norman period, when feudalism was introduced to England, the tenant or holder of a fief could not alienate, sell it from possession of its overlord.
So if you're leasing an apartment or a house, you can't sell the house to somebody over your landlord. Go ahead.
However, a tenant could separate a parcel of the land and grant it as a subordinate fief to his own subtenant, a process known as subenofening or subinfeudation. The 1290 statute of Caia and Kai Imported abolished subinfeudation and instead allowed the sale of fee simple estates.
All right, go ahead.
The concept of a fee has its origins in feudalism. William Blackstone defined fee simple as the estate in land that a person has when the lands are given to him and his heirs absolutely, without any end or limit put to his estate. Land held in fee simple can be conveyed to whomsoever its owner pleases. It can also be mortgaged or put up as security. Owners of real property.
Stop. Okay, so I've been alluding to it since we started this, that your government is your owner. So if your government is the owner of your estate, and how could the government own you? Maybe it's your birth certificate. Maybe that's the estate and land. So they don't actually physically own the land, but they own the paper associated with the land. Okay? They have the ability to do what? They can what does it say right there? It says they can sell it, they can convey it to whomever the owner pleases. It can also be mortgaged or put up as a security. That's what makes the whole monetary system. You are the security. Your signature makes the money in the loans that you sign that they're able to trade and make money off of, and not telling you that you are the king in America. Every house is its own estate and its own. You properly structured, you can be your own state. Listen to that. You can be your own state, and otherwise, until then, your owners can convey it to whoever they can please, mortgage it or use it as a security. Go ahead. Owners of real property.
Owners of real property in fee simple have the privilege of interest in the property during their lifetime, and typically have a say in determining who gets to own an interest in the property after their death. Historically, estates could be limited in time. Common temporal limitations include life estate, a land ownership that terminates upon the grantee's death, even if the land had been granted to a third party, or a term of years. A lease for a specified term, such as in an estate for years. A fee also could be limited through the method of its inheritance, such as by entailment, which created a fee tail. Traditionally, fee tail was created by words of grant, such as to, and the male heirs of his body, which would restrict those who could inherit the property. If no heirs could be found, then the property would revert to the original grantor's heirs. Most common law countries have abolished entailment by statute.
All right. Do we understand what a fee simple is? Let's back up. Boom. Fee simple versus allodial title. Now start back where we were. We're still on, let me get the sub area. Land tenures, feudal tenure, and now we're dealing with allodial title is inalienable. Did the screen catch up?
Yeah.
Okay. Go ahead. Allodial title.
Allodial title is inalienable in that it may be conveyed, devised, gifted, or mortgaged by the owner, but it may not be distressed and restrained for the collection of taxes or private debts or condemned by the government.
Don't you like that? See, it can't be a collection of taxes or private debts or condemned. So you can't use eminent domain against it by the government. You want your allodial title, people. Feudal land tenure.
Feudal.
No, we're not going to do it. Nope. Let's back up. Back up again. Now, we were at the common law of England did not provide for a way to dispose land held by feudal tenure through wills, only urban land. Go ahead.
On the urban land, and instead uses were applied, which allowed a landowner to give his hand to one or more fees.
Mm-hmm.
To dispose of it or treat it as the original landowner provided. It was viewed with distrust due to the possibility of abuse. Edward Coke wrote that there were two inventors of uses, fear and fraud. Fear in times of troubles and civil wars to save their inheritances from being forfeited, and fraud to defeat due debts, lawful actions, wards as cheats, mortmains, etc. With as many as 13 of such fees, there was much confusion over the title to land following a lord's death, as evidenced by the case of Sir John Fastolf, which lasted from 1459 to 1476. While this was a problem that needed correcting, the actual motivation of the statute was not to do so, but instead to bolster the finances of Henry VIII. For several years prior to the statute, Henry had begun struggling with the need to raise revenue. His royal lands did not provide enough loans and
Internal Revenue Services. So you got the same thing that happened with King Henry VIII, where he needs to raise revenue, so he was coming up with a way to tax people for the death or the transfer of land. Well, when the United States Corporation, there's nothing new under the sun, when the United States Corporation so-called went bankrupt, right, in 1932, okay, they had to generate revenue, hence the creation of the IRS, Internal Revenue Services. So that's taxation of all your labor when you work as a job. Basically, when you work as a fee or a tenant, that's why you're getting taxed under the feudal system of being under your master or landlord or your lord, okay, for your duties in the society that you're free to do. Okay, no one made you flip burgers at Burger King, but we made you pay taxes. Okay, so that's the same. Understand, it's the same thing that's being used is to make you a tenant, and the only way they made us tenants was through our birth certificates. Okay, I want y'all to pause right there. And go back to feudal tenures, and I want to get some more information on estate and land. Anybody else like to volunteer? I know you've been reading a second. Got anybody else that can see? Don't mind reading for us real quick. Very important term, estate and land. All right, I'll take it. An estate and land is an interest in real property that is or may become possessory In the legal system of almost every country, the ultimate true owner of all the land is the sovereign, which for a republic is the whole people of the society. So understand this: you're not considered a people of the society when you're in the tenant position. Okay, so if you're not part of the tenant position, you cannot be considered part of the whole society, people of the society. Okay, which with sovereign exclusive dominion over a well-defined tract of land may be called a state. Now, I know some of y'all are like, hey, what you mean I own the land? Yes, you do. God made Adam and Eve through the dirt, straight out the ground. Your body is land. Okay? So you do have a piece of land that you do own. Okay? Well, that you should own. I'm not going to say you do own, that you should own. Private parties own not the underlying land, but claims on parcels of lands, and that's formulated in a document. Okay, to have a parcel in land. All right, which taken together define the estate for the parcel. This is superior ownership. This is superior ownership. This superior ownership is the basis for taking land through eminent domain. Okay? Well, technically, Mom and everybody signed you up and gave you over as a gift to the estate of the state which you were born in, okay? So that's where it gave them eminent domain over you as such. Okay? However, the claims that define the estate are themselves personal property. This should be distinguished from an estate, as used in reference to an area of land. An estate, as used to refer to property in general. And property in general. In property law, the rights and interests associated with an estate and land may be conceptually understood as a bundle of rights because of the potential for different parties to have interest in the same property, called a bundle of rights. Okay, so there's always some kind of dispute when it comes to ownership, so you want to be the first in line. Okay, let's talk about some estates. Estate and land can be divided into 4 basic categories. Guys, you want to know what estate and land is. Okay, and you will notice that you've already experienced some of these. Okay, estate and land can be divided into 4 basic categories. Freehold estates, rights conveyable, exclusive possession and use, have immobility and indeterminate duration. Fee simple, absolute. Most rights, lease limitations, indefeasible. All right, so sometimes when you're looking up words and you're looking up definitions of things, if you read just the first few lines and think you know what a word means, you're shorting yourself. Usually somewhere along the way you're going to run into the full definition. They're not. It's out there, but it's not out there. If you have noticed, okay. If you did not know what a statute of use is, you wouldn't even be on track with any of this information. Okay, I've been studying this information for a very long time now, and I've just found the definition to that word right there days ago, and I already knew this information. I knew it from reading other books. I knew that this was going on, but this one definition broke down all of it in order. I hope y'all are getting this. Y'all, let me chime in with y'all real quick. I don't know if y'all put anything on the chat. All right, no one on the chat. What y'all think so far? Before we go into these last four categories, I want to know what do you have y'all ever heard of this? Is it clear? Are you seeing where this is founded in? Can you see the similarities? Okay. All right. Let's see. Freehold estates. Let's see. The feasible estates. Voidable possession and use. Okay, so these are types of freehold estates. Is voidable. You don't want the feasible estate. You got fee determinable, fee simple, subject to conditions, subsequent, fee simple, subject to executor limitations. You hear that? We definitely have some limitations on how we to operate ourselves. So your freehold estate or freedom to labor is an example of a freehold estate. Okay? Leasehold estate. Rights of possession and use, but not ownership. Okay? Did you know if you had a lease on an apartment or on a car, that is a type of use? See that? It's all types of uses. I'll give you another example. Do you own the DVD when you go to the red box? You don't. That's a lease. Renting is another form of lease. Another word for lease. That's a lease estate. Okay? Estate for years. You can do a 12-month lease or a periodic estate, which automatically renews month to month. So you might have an estate for a year with a month-to-month or bi-weekly. Matter of fact, here's a periodic estate. If you rent a hotel, you got 24-hour estate, if that, in that hotel room. Estate at will, tenancy at will, leasehold for no fixed time or period. It lasts as long as both parties desire. Termination is bilateral. Either party may terminate at any time or by operation of law. Tenancy at sufferance, created when tenant remains after lease expires and becomes a holdover tenant, converts to a holdover tenancy upon landlord acceptance. Okay? Sounds familiar, huh? Concurrent estates. Owned or possessed by two or more individuals simultaneously. That would be joint accounts. Or community property. You know, you have a community park, and then that's a concurrent estate. If the matter of fact, your homeowner association is a form of concurrent estate, and your homeowner association is your overlord, even over your mortgage. Okay, because if you don't do something according to the covenant of the homeowner association, you'll be fined and penalized and taxed. Equitable estates. This is what we want, is an equitable estate, and this is where we will close tonight. Okay? Equitable interest. It's what equitable estate means. An equitable estate is an interest held by virtue of a equatable title. A title that indicates a beneficial interest in property, and that gives the holder the right to acquire formal legal title. Take your name back. Okay, guys, take your name back. We want equitable interest. Okay. A title that indicates a beneficial interest in property, your birth certificate, that gives the holder the right to acquire formal legal title. Authenticate your birth certificates. or claim on equitable grounds, such as the interest held by a trust beneficiary. Guys, not only can you take it and own it, you can pass it over and put it in a trust. It's another form of ownership. The equitable interest is a right in equity that may be protected by equitable remedy. See that? Equitable interest is a right in equity that may be protected by equitable remedy. If you don't know what equity means, you haven't been reading your Bible. All right? You want to go in what is equity, all right, and equitable interest, all right? You definitely want to know this, all right? Equitable remedies are judicial remedies developed by courts of equity from about the time of Henry the Seventh to provide more flexible responses to changing social conditions than was possible in precedent-based common law. Equitable remedies are granted by the Court of Chancery in England. Now listen to this. It said Court of Chancery in England. Check this out. Remain available today in most common law jurisdictions. In many jurisdictions, legal and equitable remedies have merged, and a single court can issue either or both remedies. Despite widespread judicial merger, the distinction between equitable and legal remedies remain relevant in a number of significant instances. Notably, the United States Constitution, 7th Amendment, preserves the right to a jury trial in civil cases over $20 to cases at common law. So, guys, if you're getting foreclosed on or you're being sued to garnish your wages, the 7th Amendment say you're supposed to have a jury trial before they can issue judgment. Why are they skipping that process? Let me guess. You're not one of the people of the society because you are less than a human. They have you in the slave status or the tenant status. You don't get the privilege of a trial by a jury of your peers in civil cases over $20 at common law. You know how many people I've seen get kicked out of their house and moved out of their house because and without a trial by jury? So how do they openly violate that? Because you don't have a remedy in equity. You don't have equitable remedies because you don't have those rights. You're civilly dead. They own you. You go by what they say. Okay? Equitable remedies. The distinction between types of relief granted by courts is due to courts of equity, such as the Court of Chancery in England, and still available today in common law jurisdictions. Equity is said to operate on the conscience of the defendant. So an equitable remedy is always directed at a particular person, and that person's knowledge, state of mind, and motives may be relevant to whether a remedy should be granted or not. Okay, so when you walk in with an attorney, I'm going to tell you right now, you cannot have an equitable remedy. Why? Because you have an attorney puts you in the slave status, and it says that you are incompetent to speak for yourself. So right there off the rip, by state of mind and status, you will not be able to walk in with an attorney and get equitable remedy. You will have to. Okay? Equitable remedies are distinguished from legal remedies, which are available to a successful claimant as of right by the discretion of the court to grant them. In common law jurisdiction, there are a variety of equitable remedies, but the principal remedies are injunctions and specific performance. Okay, guys? So there's a variety. First of all, the injunction. What is an injunction? And we'll probably ask what we'll do Injunction, specific is performance, and we'll stop and you all can continue to read and dig in. Okay? An injunction is an equitable remedy in the form of a court order that compels a party to do or refrain from specific acts. A party that fails to comply with the injunction faces criminal and civil penalties, including possible monetary sanctions and even imprisonment. They can also be charged with contempt of court. So guess what? You can put an injunction on the police department. You can put an injunction on the IRS. You can put an injunction on your baby mama that keep throwing bricks in your car. You can put injunctions. You can put injunctions on the child support agency trying to extract taxes for a child that you birthed that you own, and trying to penalize you for being a slave and you birthed a child. Okay? So you can put an injunction on them, tell them, hey, stop trying to send people to come get me for these fees. There ain't no real money out here. Okay? The injunction is an equitable remedy. That is a remedy that originates in the English Court of Equity, like other equitable remedies. It has traditionally been given when a wrong cannot be effectively remedied by an award of money damages. Okay? This is executed when look, money is not going to pay for that leg cut off, The doctrine that reflects that this is the requirement that an injunction can be given only when there is no adequate remedy at law. Injunctions are intended to make whole again someone whose rights have been violated. Nevertheless, when deciding whether to grant injunctions, court also take into account the interest of non-parties, that is, the public interest, when deciding whether to give an injunction or deciding what its scope should be. Courts give special attention to questions of fairness and good faith. One manifestation of this is that injunctions are subject to equitable defenses such as laches and unclean hands. Injunctions are given in many different kinds of cases. They can prohibit future violation of law, such as trespass to real property, infringement of a patent, or a violation of a constitutional right, the free exercise of religion, or they can require the defendant to repair past violations of law. An injunction can require someone to do something like cleaning up an oil spill, remove a spike fence, or can prohibit someone from doing something like using an illegally obtained trade secrets. An injunction that requires conduct is called a mandatory injunction. An injunction that prohibits conduct is called a prohibitory injunction. Many injunctions are both. That is, they have both mandatory and prohibitory components because they are required some conduct and forbid other conduct. Okay? So you want to tell a debt collector, stop harassing you. You can get an injunction. Okay? Injunctions. Equitable remedy. You can't have these equitable remedies until you have authenticated your birth certificate and you are considered a landholder. Specific performance. Specific performance is an order of a court which requires a party to perform a specific act, usually what is stated in a contract. It is an alternative to awarding damages and is classed as an equitable remedy commonly used in the form of injunctive relief concerning confidential information or real property. While specific performance can be in the form of any type of forced action, it is usually used to complete a previously established transaction, thus being the most effective remedy in protecting the expectation interest of the innocent party to a contract. Okay? The innocent party to a contract. So if you demand specific performance, hey, look, man, when I come down the street, tell your officers do not touch this man. This man has nothing to do with you. He is outside of the tenant position. He is no longer in slave status. Don't touch him. Okay? Guys, y'all have any questions or have any comments? You can unmute your line, press *6.
Yeah, Brother Ben, can you get some of those definitions again? You don't have to go through I just need the names of them.
What definitions again?
The ones that we went through, it was certain ones I didn't get.
Okay, which ones did you get?
Let's see. I got scribble here. I got land tenure, feudal tenure, military tenure. I have the feudal systems.
Statute of uses.
Statute of uses. I do have that.
Allodial title.
I have allodial
equitable interest. Fee simple. And estates and land.
Okay. Alrighty.
All right. Anybody
How do I
else?
access the webinar?
After recording this webinar, you'll be able to see a replay of it. You can Google this information.
Alrighty.
Everything we looked up was on Wikipedia tonight. All right, guys. Y'all have any other questions?
All right. I was scrolling down the page, looking at the authentication process. It's something here from Denise W. Merrill from Connecticut Secretary of State. Do I need to find the process from my own state, or does this cover all of the? Okay.
Yes, your birth certificate was issued by your state where you were born, and you need to turn that copy into an original. So you need to go to the authorities in that state and go up the chain of command. If your birth certificate was signed by a county register, a state register seal is on your document, and you can see your mother's signature and your dad's signature, one or the other. It's usually one or both. You need to go to the Secretary of State and get your birth certificate authenticated at the Secretary of State in your state, the state that you were born in. Okay? If you were born in New York or some places in California, in your city, and it says you have a city register on your birth certificate, you have to go to the county clerk of the city that you were born in.
Okay.
And you must get that clerk seal, and then you go to the Secretary of State, and then from the Secretary of State you go to the federal level. Okay? From Secretary of State, you always go to the federal level. You can find this information by Googling on your computer. Authentication for the state that you want. So authentication. Alabama. Boom. Alabama pops up. The PDF pops up for the submittal form, and the Secretary of State website pops up for authentication. And they explain to you that there are two types of authentication. The type of authentication Alabama documents require for foreign use is based upon the country in which the document will be used. If the country in which the document will be used is part of the Hague Convention, a apostille will be affixed to the document. So if you pick England, Spain, France, Italy, okay, you pick any of these places, they're going to give you an apostille, and that's not what you want. Apostille is still inside the jurisdiction, so we're not wanting to be part of the Hague Convention. You want a authentication, which is a country outside of it, which is called certification. The certification may be affixed to documents bearing the official seal and the seal of currently commissioned Alabama probate judge, circuit court, or current Alabama state register. Okay, that's a totally different type of certification. It certifies that the information on the document is true. An apostille does not. So if you get an apostille, you got the wrong document. Okay, grab your birth certificate and start the process. When you get your state back, then you're going to send it to the Fed level.
Okay.
Federal authentication. Google authentication. Authentication.
Got it. Okay. Authentication Florida is what I got in. I got a couple of different. You say you don't want
authentication. Federal. Department. I'm speaking to everybody. I'm answering your question, but I'm speaking to everybody. Authentication. Department of State. Department of State is the federal government's authentication website. And you can find the mailing address and the physical address to send your document after you've gotten it back from the Secretary of State. Okay? Each state is different. Just find the for ABA, you are naturalized. You're going to deal with the county. You came to a county in New York, so you want to get that county seal. You need to look and see who's the seal on that naturalization form. Whose seal is that, and who's the next level, the boss above that? Whoever the boss above that would probably going to be the Secretary of State or some kind of county seal. So you need to check to see what that seal says. If you find that out, I can probably help you real quick. Okay. If you're Florida, Georgia, Connecticut, just find your Secretary of State associated with it. Mind you, if you have a seal that says it has the city of a city, you must get the county clerk's signature before you send your document to the Secretary of State. You must, because you would have missed a central piece. This is government 101. Just like you have a king, a lord, and then landholders, and then tenants. Okay? Well, in this government, you have the people, then the government, the president, and then from the president down to the president, the federal level, as part of the federal level, from the federal level to the state level, from the state level to the county level, from the county level to the city level, from the city level to the neighborhoods, to the homeowner associations, and so forth. Those are even further forms of sub-government. Okay? If you have a city seal, the next level of government is the county. And then from the county, you go to the Secretary of State. And then from the Secretary of State, you go to the federal level. That's what authenticating your birth certificate is. We've covered it in other classes on why and exactly how. I'll repost the video on that. But it all entails why you want to get that title. Entails, are you fee simple or do you have an equitable estate? Okay? And the way we get that is you get that authenticated birth certificate. If you do not have your mom and dad's signature, sometimes you do run into, they will go over, if you try to go to like an outsourced branch that provides birth certificates, they're probably not going to have the one you need. You probably want to order your birth certificate directly from the county or the state register or the capital and get it straight from them instead of going through alternative sources that are not giving it to you. Okay. All right, guys. Go ahead.
I got the long form from Vital Check, and it actually is the copy of my real birth certificate that I remember, the true one from the beginning, and it actually has a signature.
Where you from?
From the Bronx, New York.
Okay, that's awesome. That's awesome.
But it doesn't have my parents' signatures. It has the doctor's. I see the doctor's signature. Abdul whatever.
Okay, in New York, the parents don't sign it. The doctor eyewitnesses it. They actually take it a whole nother level of trying to pull them out of the situation, because what happens is if your mom and dad signs it, they become a party to the contract, and they're able to still have a claim in the title. Okay? Your mom, dad, and you got a claim in that title. You know what I'm saying? Or you and your mom. All right?
Yeah.
But in New York, they don't even want your mom and dad's signature on there, and the doctor is the witness of the state to say that, yeah, this baby came out of these waters, and it belongs to the state now, and the doctor's signature. So, yeah, you're right. In New York, you do not have your parents' signature. You have the doctor's signature.
They also sent me this form called Exemplification of Birth or Death Record, and this lady named Deborah J. Boyce signed it. She put a seal on it. I don't know what it's for, because I found the directions. I found the exact step-by-step directions for authenticating from the Bronx or any of the 5 boroughs, and it doesn't mention using the Exemplification of Birth or Death Record. So what good is the form for me?
I have not ran across that, and what I will do is save that for another class, and I will look up exemplification. Put a picture of it in the class, and give me some time to go over whatever that form is. All you need is that original title and start authenticating up.
Yeah,
okay?
they say
that exemplification. If you got the New York form, you need to go to New York and go to the bureau, the city register, the city clerk, and go to the bureau correspondent for you and get that seal for the first. That's your first authenticating step.
Yeah, I know exactly where to go and all that, because it's step by step online. And I actually called them and spoke to somebody. And nowadays you can actually do it in the mail, but it takes way longer. So I'm gonna just fly there and do it. But
yeah.
I'm muted. I had all the information I needed, And as far as you're saying, I just need my long form and I'm good.
Mhm.
Okay.
But I want to know what they're trying to do by giving you that exemplification thing.
She
sounds like Yeah, I need to break that down. Take a picture of it. I'm interested in that information or whatever it is they sent you, but I don't want to put it on this class.
Okay, yeah, I'm interested as well, because I'm from the Bronx and I'm going through exactly what he's saying.
Oh yeah, well I'll post the link that I have for New York. Maybe that might help you like it's helping me.
Yeah,
I'm talking about the form that she hand wrote out. So that's cool.
Yeah, I'm
for that step by step. But that hand form, whatever that is, I want to know what she's trying to express. So I want to read the whole verbiage. That sounds like a contract to me, and then you need to know the verbiage of it. So it's more than one word to be looking up when trying to break that down.
Yeah, I'm gonna post it. What it appears to be to me, and I don't understand the law as great as you, but it appears to be something to say that this long form that they sent me is a true copy. That's what it seems to be, but I don't know.
Even a form or handwritten, like, hey, yo, you got the right one. Well, yeah, that sounds cool too. That's cool. In Alabama, we don't even have to go through that. They give you the one your mama signed. Off the real. You just ask for one in Alabama, and just the one your mama and daddy's signature right there on it. No trickery, no short form, nothing.
That's cool. You
see?
Yeah, brother.
All right. If you try to do the online authentication for Florida guys, the price is a lie. You need to call them directly. Sometimes some of this stuff, it ain't that easy. Walk and click a button every time. And sometimes you can mail it. A lot of times you can't mail this stuff. But getting the right copy could be tricky. And getting and sending out the mailing it to the Secretary of State is easy. But you got little stuff with different states that have their own little nuances. So you got to look it up. I can't look up every state.
Okay.
Gotta look at
everything that
you know what I'm saying. That's only fair. Go ahead. The website might be called Apostle, but they give you certifications too. That's another trick.
Okay.
Okay, it might be the apostille of Florida. You be like, hold on, man, he just said no apostille. You go to that website and look, and there'll be a spot to say, oh, here go to certifications.
Okay.
Okay. Very important step. Take your name back.com. Send your friends there. They need to understand. We're going to start dropping more information on there. I love being able to bring this to you guys. Like, I promise you, I've never seen what we just went through in class tonight, I've never seen a line of definitions in order breaking down this information just like that. I just found that. Okay? And looking at that in how order and how it's pretty much clear for some of you all who's never been on a class, it's still a lot of verbiage. You're like, what in the world? But I'm reading a book, and this book had a word called Quintilius Juris. And this is your homework, and y'all can take a look at this. Please unmute yourself, somebody. I think it's hold on. That's good. All right, Quintilius Juris. I'm giving you a bonus one. I was reading a book right now. It's like 1940s on filing a suit in equity. And hold on, it'll pop up, I think. Let's see. There it is. Quintilius. Yeah, I spelled that all wrong, guys. SCIN. Okay, Quintilius Juris. When you look up the definition of Quintilius Juris, I'm literally reading through a long book, and I'm looking up this. And I see this one word. End up finding a whole book I have to read to even begin to even start breaking down this information. Look at how it speaks. Quintilius Juris, estate, a spark of right, a legal fiction, resorted to for the purpose of enabling fees to uses to support contingent uses when they come into existence. Does that anything about that sound clear and definite to you? Doesn't it sound very vague? I mean, how many definitions do we look up when we look up on here? And it's just certain words you get to, it's just don't be nothing on it. Okay? They don't even really want you to even know what that means. Okay? Listen to this. It says, thereby to enable the statutes of uses, okay, guys? From 27 Henry the 8th to execute them. That's so short. To execute them. We just read it. And to see them even put that in there and just kind of act like, yeah, that's the definition of it. Like, you know how much reading we just did to even begin to understand what that's talking about? Okay? Also, 4th Kent Com 238. That's the book I'm reading right now. That's a whole book of definitions dealing with property law. Okay? And I'm sure y'all can go back on what we read tonight and find 15 or 20 more words you can be looking up and figuring out the definition of it. And you'll see you keep coming over the same words. And when you learn the multiplicities of the words, you'll see it's only a few words, really. So, it's when you're starting to see that all these are the same set or group of words and they're grouping, man, this stuff becomes easy. All right? And they say God is the Word, and the Word is with God. Bless you guys. Keep reading your Bibles because that's where the original trust and estate. For the children of Israel, you have an equitable estate in the kingdom of heaven over the entire planet, and you have a birthright estate that has the highest allodial title on the face of the planet. Bless you guys. Okay? Shalom.
Shalom. Most High bless.